Hi, my name is Aurelia Schultz. I'm a member of the Executive Committee of the Intellectual Property section, and I'm going to be giving you the brief version of what you always wanted to know about patents, trademarks, copyrights, and trade secrets. It's going to be a very quick overview since we have so little time, but the goal is to help you understand the differences between those four main areas of intellectual property law so that you know which ones to explore when something comes up. So we're going to start with trademarks a little out of order because I've been told if you start with patents, everybody falls asleep and then you have to rewind your video. You don't want to do that. So trademarks, the official definition, I'm going to read this because it's a bit long, is a word, phrase, symbol, or design, or any combination thereof, used in commerce in a manner that identifies and distinguishes the source of the goods of one party from those of another. So basically it's a brand or a logo or a slogan. And trademarks are important for a number of reasons. One of the big ones is money. Trademarks are often the most valuable asset that a company owns. They're also important because of goodwill. A trademark shows a customer what the source of a good is so that they can rely on their previous experiences with that brand or that company. They're also important for advertising purposes to help customers identify goods. There are many different types of trademarks. There are symbols or pictures, words, numbers, slogans, colors, sound, scent, even touch. And there are different strengths of trademarks, ranging on a scale from generic to fanciful. Generic being the least strong of a trademark, where the name is really something anybody would use to describe the item. The next level is descriptive, where the trademark kind of tells you what the product or service does. So for example, park and fly. The next level beyond that is suggestive, where it's not an actual description of the product, but kind of gives you an idea of what it's going to do. So for example, copper tone for sunscreen. The next level beyond that is arbitrary, where you've got a word that's common but applied to something it wouldn't normally be applied to. The most common one of this that most people are familiar with is Apple, as it applies to computers. And then the highest strength for a trademark is what's called fanciful, which is where the name's actually made up. So for example, something like Xerox. There are three different levels of trademark protection. The most basic level is common law protection. You get this protection automatically by using the mark in commerce, and you get this protection anywhere that you're using the mark. The next level is state protection. This is where you can register your trademark with the state. This gives you protection across the entire state, no matter where you're using the mark. And the highest level of trademark protection is federal protection. In order to apply for federal trademark protection, you have to use the mark in interstate commerce. And once you obtain federal protection, you're protected for the entire country, regardless of where you're actually using the mark. And length of trademark protection can be indefinite as long as you continue to enforce your trademark and to keep your registrations renewed depending on what level you have registered. And trademarks can die in a couple different ways. One is called genericide. This is where your brand name becomes the generic name for the product. So for example, something like escalator or aspirin. And another way that your trademark can die is through abandonment, where you stop pursuing the mark, stop enforcing it, don't follow up on your registrations. Patents. Patents cover inventions, and patents are covered by Title 35 of the Federal Code. And there are two main types of patents: utility patents and design patents. Design patents cover ornamental designs of things. Utility patents are the ones that we more commonly think of when we think of patents, and these cover new and useful inventions. So in order to qualify for patent protection, the invention has to be novel, it has to be useful, it has to be non-obvious, it has to fall within patentable subject matter, which differs by country, but thanks to international treaties, those things are kind of aligned across international borders. And then your patent has to be enabling, which means that somebody else could look at your patent and would have the information necessary to produce the same item. What you get when you get a patent is you have the exclusive right to exclude others from making, selling, importing, or offering for sale the invention. And the term of patent protection is 20 years from the date of filing. The U.S. is, as of fairly recently, a first to file country, which means the first inventor to file their patent application is the one who will obtain the patent. And patents are obtained by filing with the USPTO, the Patent and Trademark Office. And in order to file a patent application as an attorney, you do need to be a member of the patent bar. Next, we have copyright. Copyright covers creative works fixed in a tangible medium of expression. So these are things like photographs, music, writings, paintings, that sort of thing. Fixed in a tangible medium of expression is the magic language from the Copyright Act. And I like to think of that as the work is put into some sort of format that can be shared without the original creator's involvement. So once it's on paper, on a CD, has a link on the internet, that sort of thing. Copyright is covered under Title 17 of the Federal Code, and what you get with copyright is you get a bundle of rights, and there are 4 main rights: the right to make copies, the right to distribute copies, the right to make derivative works, and the right to publicly display or publicly perform the work. Copyright's current term is 70 years beyond the life of the author, and you get your copyright automatically once you have fixed that creation in a tangible medium. However, in order to enforce the copyright, it needs to be registered with the U.S. Copyright Office. So I like to think of that as sort of insurance, because you have your copyright, but you can't do anything with it unless it's registered. So you can't bring a suit. Well, you hope you never need to use that registration, but if you do, you're going to be very glad that you have it. And then there are some limits on copyright protection. The biggest one of these is, kind of most famous one, is called fair use. Fair use was originally created by the courts. It was codified by Congress in the copyright law, and it's a 4-piece balancing test. And what you need to take into consideration to decide if something is fair use is the purpose and character of the new work, the nature of the original copyrighted work, the amount of the original copyrighted work that's used in the new work, and then the potential market effect of the new work on the original copyrighted work. And then lastly, we have trade secrets. Trade secrets protect secrets. In order to be protected, it needs to be kept a secret. It's the big thing with it. The most famous example of a trade secret is the recipe for Coca-Cola. In addition to protecting recipes, trade secrets also protect things like customer lists, computer source code, pricing information, that kind of thing. There's no federal law covering trade secret, it's all state law. And in California, the trade secret law is in the Civil Code, it's section 3426. And trade secret protection lasts indefinitely as long as, once again, you keep it a secret. And so in order for keeping something a secret, that thing that you're trying to protect, it cannot be generally known to the public, and it cannot be easily ascertainable by proper means. So in order to protect your trade secret, you actually do need to take efforts to keep it protected, and you can do this through things like employment agreements and non-disclosure agreements. Trade secret protection does not protect whatever the item is that you're trying to protect from things like reverse engineering. So if you were to go in your kitchen and somehow figure out the recipe for Coca-Cola on your own, that wouldn't violate their trade secret protection because you figured it out on your own. You didn't find their secret. So that's how that works. So overview, trademark, brands, logos, company names, patents covering inventions, copyright covering creative works, and trade secrets covering secrets. Thank you.